Here is my motion to dismiss. City of Natchitoches versus me. Comes now, the defendant Travis Hines, pro se, hereby moves this honorable court to dismiss the charges and complaint filed in this matter with prejudice for failure to state an offense and defect in the underlying statute, and requests the court to take judicial notice of the Bill of Rights of the Constitution of the United States, the Declaration of Rights within the Constitution of the State of Louisiana. While the charge of resisting an officer under Lars Tit 14-108 is and should be a serious offense. The statute's use in this matter, however, raises serious statutory defects to its excessive vagueness, overbreadth, and violation of equal protection, as defendant had constitutional protections guaranteed by the Bill of Rights of the United States Constitution and the Louisiana State Constitution to be free from government intrusion and false arrest. Defendant Hines, a United States American citizen, was patronizing a publicly taxpayer-funded public library known as the Natchitoches Public Library, located at 450 2nd Street, Natchitoches County, City of Natchitoches, which primary function and purpose is to serve the citizenry and public at large without membership or admittance fee, and must allow all citizens to share and use the publicly accessible space at their will or leisure without prejudice to their appearance, physical or mental handicap, nationality, sexual orientation, or color of their skin. Although patrons of a public library must adhere to the laws of the state of Louisiana, ordinances of the city of Natchitoches, and policies of the library, the mere physical presence and physical appearance or perceived handicaps of patrons who are unknown to the library staff or local law enforcement does not give rise to reasonable suspicion, nor probable cause, to detain a citizen for questioning or interrogation for personal information or their purpose and intent of utilizing a public library or public forum. Complainant Officer Jordan Davis writes in his report that the defendant was acting weird and made efforts to conceal whatever contents he was taking out. But Complainant Officer Davis fails to explain any criminal behavior or offenses committed by the defendant in violation of Louisiana statutes or Natchitoches criminal ordinances that gave him reasonable suspicion to detain defendant Hines or any subsequent probable cause to effect an arrest. A prerequisite or element of charging the crime of resisting an officer is that the offending party must be first arrested or detained for a criminal violation. Defendant Hines had not been detained or arrested when asked to produce his identification. Defendant Hines was involved in a consensual law enforcement contact, was at no time defiant or unreasonable, and was communicating with law enforcement. Defendant Hines did not refuse to give his name or make his identity known, and at no time gave false information. Defendant Hines was asking questions to the nature, reason, and cause of the consensual contact when he was wrongfully arrested. At no time did library staff ask Defendant Hines to leave the public library or accuse Defendant Hines of any policy violations. According to Complaint Officer Davis, library staff did have contact with Defendant Hines and asked if he needed help, which Defendant Hines inquired as to what kind of help the staff was offering and did not seek the staff's assistance. Asking questions to law enforcement officials is protected speech and cannot be cause for arrest to silence a citizen. In the United States of America, a citizen has protected right to make inquiry to law enforcement officers who engage the citizen. A citizen has the right to be informed of the purpose of the contact and the intentions of the officer. In this matter, the contact by law enforcement was a consensual contact, as there was no evidence that a crime was afoot. This is supported by the fact that no criminal charges were alleged or charged by law enforcement that would have supported their initial contact. Suspicion of criminal activity must be supported by facts after conducting an investigation. No facts were obtained by law enforcement which give rise to reasonable suspicion of a crime having occurred by the defendant. No investigation was conducted to identify any criminal activity, or behavior of the defendants. The defendant was never told he was under custodial detainment at any time, No articulation of any crime was ever proffered to the defendant prior to his eventual arrest. Defendant Hines had no legal obligation to provide law enforcement with his personal information or identity, as he had not committed any crime, nor had he been detained or arrested when asked for his personal information. The statute in question is excessively vague, as a citizen has the right to be secure in the person and effects under the Fourth Amendment to the Bill of Rights in the Constitution of the United States of America. When law enforcement approaches a citizen in public and asks questions, the citizen has the right to not engage with or answer questions. This is a fundamental right known by and taught to all law enforcement personnel nationwide. Defendant Hines was engaged by law enforcement in a consensual contact and was willing to have limited communications with them to ease any concerns that they may have had about Defendant Hines's actions or motives. Instead of allowing any discourse, law enforcement wrongfully arrested Defendant Hines. One must first be in custodial detention or investigatory detention for a crime which law enforcement must be immediately able to articulate before the statute at bar could be applied. The statute as written fails to directly state the obvious elemental requirement prior to its legal enforcement, and therefore is a constitutional violation. Law enforcement is held to a higher standard of scrutiny and cannot be the victim of issues of public concern. The victim of a violation of public concern must be a member of the public without a governmental interest in the matter at hand. Either the complainant's victim is an agent or personnel of the library or the people of the state of Louisiana. This statute seems to permit law enforcement officers to be personal victims by way of their title and profession. In this matter, the complainant, Officer Jordan Davis, files the charge as an individual. Officer Davis asked Defendant Hines for his identification without having first placed Defendant Hines in either an investigatory detainment, a custodial detainment, or under arrest for a separate or pre-qualifying offense. He then arrested Defendant Hines as both the initiator of the action to which he claims to be a victim and as a government agent with the presumed authority to effect the intended result, arrest. This appears to give rise to governmental entrapment, as the victim is also the arresting officer. The indictment in this matter is insufficient on its face. The charges fully and clearly specifies the acts defendant is alleged to have done, but these acts constitute no crime. The charging documents is wholly conclusory, lacking specific allegations of criminal conduct. The indictment must allege facts to support the allegations and sufficiency to charge the offense. In this matter, a person must be first arrested or detained for a lawful purpose prior to being charged under this statute. Further prosecution of this matter would constitute malicious prosecution, as the court does not have jurisdiction to sentence a defendant for that which is not a crime, and the defendant has an immediate expectation to not be held accountable to crimes he did not commit or where he had well-established constitutional protections afforded him. Whereas, as the aforementioned reasons, defendant respectfully requests this honorable court grant this motion to dismiss the charge and complaint filed in this matter with prejudice for failure to state an offense and defect in the underlying statute, and order the dismissal of this case with prejudice. And then also, you also follow up with a separate document writing the rule to show cause. And the Judge Robert Owsley signed this rule to show cause. It is hereby ordered that the district attorney show cause on the 15th of February, so that's in a week and a half, 2 weeks, while the foregoing motion to dismiss the charge and complaint filed in this matter with prejudice for failure to state an offense and defect in the underlying statute should not be granted. And then he signed it. So that's the step I took, and just have to wait. Whoop.